The bank is saying, we are not going to release you of liability. We are not going to release our lien. To the contrary, we will not release our lien unless you agree to sign a promissory note for $50,000. And the realtors are encouraging them to do it. Don't go there. Don't go. In the case that most recently came in, it was a scenario where the client had 2 loans on the property and they were both purchase money. I said, my God, what's this realtor thinking? Fortunately for the realtor doesn't know how lucky he was that the client came to see me, because I saved him. No promissory note's going to be signed. If the client would have come to me after signing the promissory note, then the realtor would not be lucky that the client had found me. Don't go there. Don't have them sign a promissory note. Have them talk to a lawyer first, because if they don't have an obligation to pay, why should they sign a promissory note? We are seeing. I don't understand the randomness to this. I do see the banks providing short sale agreements and loan modification agreements that do contain a signature line for the bank. But by the same token, I see a lot of short sale agreements and loan modification agreements that don't contain a signature line for the bank. Why? And then I see the exact same bank in one transaction have a signature line, and then the next transaction with a different client, no signature line for them, and they take a hard line position saying, we refuse to do that. But you did it over here with this other guy. Why won't you do it over here for this guy? That's just why we do it. Oh. Okay. Okay. Now, I'm going to tell you, this is just my speculation, my theory, what I think is happening. The banks are waking up to this Seacrest decision, statute of frauds. If they provide the client with a loan modification and the bank doesn't have a signature line, so the bank's not signing it, the bank has just created a cash flow stream for themselves until the market turns around. And then when the market turns around, they get to sell the property. Much to the chagrin of the homeowner, but much to the benefit of the bank. And if you think about it from the bank's perspective, what better way to make themselves whole? From their perspective, it's all about them. What do I do to make myself whole? That's me speculating a little bit, but I think it's a brilliant move. If that's what they're doing, it's a brilliant move.
How about in my companies asking sellers to sign promissory notes?
What's that now?
How about an MI company?
I'm sorry, I can't hear you.
How about a mortgage insurance company asking a seller to sign a promissory note?
Right.
I mean, what would you advise on that?
Well, it doesn't change the nature of the question. The question then becomes, do they have an obligation to pay? If the homeowner doesn't have an obligation to pay, why sign a promissory note? Yeah, the lady up front brought a valid point. The minute the client's being asked to sign a promissory note, get the football out, drop it, punt. Yeah, you got to send them off to an attorney to figure out whether or not they have an obligation to pay. Because if they end up, because I'm going to be honest with you, ladies and gentlemen, the perfect storm is coming together. A lot of these people, if not all of them, the majority of them, are probably going to find their way into a lawyer's office within the next year or two, because they can't hold on. and they're going to be filing bankruptcy. And if it's that promissory note, that's the straw that's breaking the camel's back, or if it's large enough where that's the sole reason that they're filing bankruptcy, then the real estate professional that got involved is going to be scrutinized. And again, you do not want to be in a deposition sitting across from a table from a lawyer where the lawyer's asking you, how is this transaction in your client's best interest? Because that's a great, great question. Because the lawyer just sits back, smiles, and listens. The question is symbolic of the noose. The answer is symbolic of the tightening of the noose. You know, we got fiduciary duties to these clients. How is that in their best interest? They didn't have to pay the $50,000. Then why sign a promissory note for it? Right? Lawyers, let's hang on those guys for a while. You know, deservedly so. It used to be, up until, I don't know, a few months ago, you saw a boatload of TV, radio commercials, loan modifications. Right? A bunch of them. Ladies and gentlemen, lawyers are no better than anybody else. We have, our society right now is experiencing a loan crisis, a debt crisis, and it's caught up to everybody. But since there's so much of it out there, you've got every Tom, Dick, and Harry coming out of the woodwork, whether they be a lawyer or a realtor, saying, we can help. We can help. Notwithstanding my lack of experience or lack of knowledge in the subject matter, I can help. And everybody's lost sight. They've lost sight of what's really going on here. You got a borrower not paying his bill. He's in breach of contract. Bad things happen. Most of the lawyers, you don't see those commercials anymore, do you? No. Why? Well, those lawyers have been put down. They've been put down. Most of them, or they've either been put down or they've gotten out of the business. They've realized, oops, we're in over our head. We were getting ready to sue a law firm for a client about 6 months ago. It was comical. I mean, these guys were just, they were nutty. And I won't tell you who they were because they're not around anymore. But one day, we're talking to them, and they're in India, talking to call centers in India. So we're talking to the lawyers because we're telling them that they're bad guys. And when we're talking to the principal of the law firm, he was in India shopping around call centers to get Indians fielding loan modification calls and handling loan modifications. Within a month of that phone call, him being in India, getting ready to just ramp up and expand his base of operation, the lawyer had surrendered his license to the state bar, and he was looking at being sued. He's being sued by clients. And as we see here today, I don't know what happened to him. He's probably running over the horizon, hoping nobody's chasing him. I don't know.
He's in India.
Yeah, he's probably living in India. Common sense here goes a very, very, very long way. It really, really does. What about these lawyers that are out there saying, we'll do a forensic loan on it? You guys hear about those?
Yes.
Man. First of all, what that's premised upon is predatory lending. There is no body of law that's called predatory lending. It doesn't exist. I challenge you to find it. Go on the internet, find it. It's a term of art that's used to describe other areas of law that have to do with loans, like the Truth in Lending Act or the Real Estate Settlement Procedures Act. Now that's what they're looking for. These forensic loan audits by these lawyers come on, we'll guarantee you we'll find violations in your file. Well, let's talk about that. The client, here's how that works. The client comes in, and I'm telling you, very seldom do I have a client come in with an impeccable file. They come in and they got a shoebox with stuff in the shoebox. You know, they got it's a mess. Envelopes and things are missing. It's a mess. So naturally, the client's file is incomplete, either because they weren't given the paperwork originally, they've misplaced it, they lost it. Who knows? But naturally, if the client's misplacing papers or is disorganized, the papers aren't going to reconcile with one another. That doesn't mean the bank necessarily violated any of these laws. It just means the client's disorganized.